This is an interview with Barbara Black for the SEC Historical Society's Virtual Museum and Archive of the History of Financial Regulation. Today is June 7th, 2022, and I'm Kenneth Durr. Professor Black, so good to talk to you today.
Oh, it's great to be here, Ken. Thank you.
I really appreciate the opportunity. This is a little out of the ordinary for the kinds of discussions we have, so I'm really looking forward to talking about the Arbitration Clinic. But framing it in some other parts of your career.
Sure.
So by way of doing that, let's go back to the beginning and talk about your undergraduate education and when you started to think about law.
All right. So I went to undergraduate school at Barnard College in New York City in the 1960s. So that was a tumultuous time, to say the least. Vietnam War, protests and campus disruptions. I was a liberal arts major, and like many liberal arts majors, and I actually do not recommend this, but I did it. I graduated and I didn't know what to do with my life, so I thought, why not go to law school? And so I did. I entered law school in 1970. I had very little knowledge of law. Again, I'm not recommending this to people today, but I had very little knowledge of the law, and frankly, even less knowledge about business law. But there I was at Columbia Law School in 1970, and I loved law school. I loved many of my professors. I enjoyed the Socratic teaching method, and my interest in business law, corporate and securities, really stems from my experience at Columbia. I had some very fine teachers, William Carey, who had previously been SEC commissioner, Harvey Goldschmidt, who later became an SEC commissioner. And so that was my introduction to corporate and securities law.
So people like William Carey, Bill Carey made a difference, I guess.
Yeah, absolutely.
Yeah.
Absolutely. He's one of the really great figures in corporate law, and a real public service, a real public servant. What he did as chair of the SEC.
So did you decide to get into securities law at that point?
Yes, I did. I enjoyed it. I liked the technical aspects of the law, the reading of the statutes, the reading of the rules. There are also obviously very many significant policy issues, but I think I got into it initially because I did like trying to figure out what the statutes meant, and what is a security anyhow, and I found that very intriguing.
Yeah. So it sounds like this fed into some of the things you did as an academic later on, which we'll get to. But you went into practice.
I did. I went into practice, and I had what I think in the 1970s was a very typical junior associate experience at two law firms, one in New York City, one in Washington, D.C. Some of the work was interesting. A lot of the work was not interesting. But I was fortunate. I got to work with some really fine lawyers. I worked with Barbara Thomas Judge, who later became an SEC commissioner. And I know you've interviewed her. She recently died, but I know you interviewed her for this project. I worked with her at Case Scholler in New York. In Washington, D.C., I was at Rogers and Wells, and I worked with John Lifton, who had previously been director of market regulation at the SEC, and I know you've also interviewed them. So I think it was a good learning experience.
And there's something that's like should be a comma at the end of that or something. A good learning experience, but what turn somebody in the direction of moving toward academia, certainly in your experience?
I think, Ken, if you talk to almost everybody who made the move from practice to law teaching, a common theme would be we loved law school. We really loved learning in law school, and we loved the way we were taught in law school. Many practitioners, many very fine practitioners, do not have that same feelings about law school. But I found it so intellectually stimulating, and I think another probably key theme is you go into academia because you want to think deeply. You want to dive deeply into areas of law that interest you in a way that you simply can't do if you're in practice. I mean, you're on a clock, right? You're going to bill a client for your time, and you can't go down the rabbit hole and look at things that strike you as interesting or unusual. So I think that's it. I enjoyed the experience I had at law school, and I wanted to think more deeply about areas I was interested in.
I'm always looking for influential experiences, and you had a little interlude where you were with the Association of American Law Schools.
Mm-hmm.
Is that right?
Yes.
What did you get out of that brief experience?
It was. I learned a lot about different kinds of law schools. I mean, I went to one law school. Obviously, I went to Columbia as a student, and then at that time, I had taught at one law school, Pace Law School, for a number of years before I went to the association. So it was a way of seeing how other law schools operated. I met a lot of academics. You sort of learn more about the operational issues that face law schools, financing, outreach to students. So it was a good rounding experience of thinking about something else rather than simply thinking about the law.
Okay, and you gotten a grounding in academia already by being at Pace. Let's talk a little bit about those first few years.
Mm-hmm.
The program was fairly new when you came in, is that right?
Yes, yes. I joined the faculty at Pace Law School in its third year of operations, and I was part of a rather large cohort of new faculty members, most of whom, like me, were new to academia. So as you can probably imagine, it was somewhat of a chaotic experience. We were all trying to figure out what we were supposed to be doing. We all came to Pace with our own idea of what law school should be like based on our experience with the only one we knew. The university had an excellent business school, but it was having a law school was new to it, and there are differences between a law school and a business school. So you spend as a new faculty member at a new law school, you spend a lot of time on administrative issues, which nobody, frankly, well, I guess some people enjoy it, but most people don't go into academia because they think I want to do administrative work. Some people probably do, but certainly not me. And so that was challenging.
So you're talking about how to structure the program, things.
Yeah, how to structure a program. You set up committees that sort of, law schools. The theory is that the faculty run the law school, that people think that it's the dean. The dean is like a CEO. But actually, it's supposed to be a faculty-led institution. And so you have to have committees to recruit faculty members, to recruit students, for all kinds of things like that.
And in the meantime, you're starting to do some publication. I think you'd probably been doing some already. And it looks like you were really just picking up really interesting pieces of securities law and writing about them. Can you generalize about some of that early academic work that you did?
Yeah, I was in academia then, and I was writing for academic journals, but I was coming to it very much influenced by my experience in private practice. And I focused on real world issues, the issues that were really current and important in the securities law field. And um, I think I like to think that I write in a very clear and concise style, and I owe that again to my experience in private practice. That is one of the things at a good law firm you learn. You learn how to write clearly and concisely. So yeah, I think that was, and I tried to look for answers. I tried to find solutions. I recall some of my colleagues criticized some of my writings because they said they weren't theoretical enough. And that's probably true in some instances, but that what I was interested in are, again, real life problems and trying to find some solution. I think at my heart, I'm a very practical person.
Yeah, having read a lot of legal journal articles, yours stood out, I think, certainly the early ones, because you were making sort of recommendations, this is the way the commission should look at this.
Exactly. Yeah.
Yeah. Well, let's get to one of the most important ones. In the early 80s, you did something on fraud on the market.
Yes. Yes.
And let's talk about that concept. Let's talk about how you handled it, what your point was, and where
Okay.
that article went.
Okay. So under the common law tort, which is actually sort of the underlying foundation of federal securities law, it's essentially a tort action of fraud or deceit. And under the common law principles, a purchaser of securities had to prove three elements. One, that the purchaser relied on a misstatement about the security. Two, that the misstatement was materially false or misleading. And third, that the misstatement caused his injuries. Now, by 1984, federal securities class actions were coming into their own. They were a way where you could have a class of small purchasers who had purchased stock in a corporation. And their individual damages claims would not be large enough to make it financially worthwhile for them to bring an individual action. So they were the notion was to combine them in a class action. Now, the problem with that was, again, this notion of reliance. Did those purchasers have to individually prove that they relied on a corporate misstatement? And in most of these cases, they were purchasers. You can have class actions with sellers of stock, but the typical cases is someone who purchased the stock at a time when when the corporation had allegedly made misleading statements that inflated the price of the stock. So they were saying essentially, I paid too much for stock. It wasn't worth what I paid for it.
Right.
So if these purchasers had to prove individually that they read that statement and then relied on it, well, we wouldn't have a class action. And let's face it, most purchasers of stock don't read those corporate filings. Why should they? That's why you have brokers or investment advisors. They're supposed to be advising you about what stocks to purchase. So in my view, purchasers shouldn't be, if they want to read them, fine, but I don't think it's a prerequisite to bringing a claim and establishing that you've been damaged by it. But anyhow, that was the situation in the early 1980s. Can you have federal securities class actions? Which again, if we don't have those, these small investors are not going to be able to recoup their damages.
Right.
And how are we going to then deal with this question of reliance? So that's, it's a pretty intriguing issue. And that's where the fraud on the market notion came up, that false information. I mean, fraud on the market can be expressed in a lot of different ways. And there's some, you can make a fair argument. Maybe it's not a theory at all because it's pretty, it can get pretty diffuse. But sort of the conventional thought, I think, on this is that false information, that allegedly false information made by the corporation is embedded in the price of the stock. And so every purchaser who purchased that stock at that inflated price could be said to have relied on it. So that's the fraud on the market theory. And then so the question was, well, yeah, is the Supreme Court, which is the final arbiter on federal securities law issues, what does the Supreme Court think about this? And so in 1988, the Supreme Court, in a case called Basic Inc. against Levinson, adopted a version of the fraud on the market theory and said that purchasers could take advantage of a rebuttable presumption of reliance, and that would allow the federal securities class actions to go forward. And what was great for me as a young academic at that point is both the majority and the dissenting opinions cited my article, which was pretty cool.
And what was the article's contribution? Was it a descriptive work on this is what fraud on the market is, or was there a little bit of this you're laying out that it was a bit of a grab bag?
Yeah. So it really was a deep dive into what the theories out there on fraud on the market were, the various approaches. Was it, for example, the approach that the approach that the Supreme Court took was this rebuttable presumption of reliance. You can also argue fraud on the market to a stronger position, which is don't have to show reliance at all. All you need to show is essentially causation, that the information was in the stock, and so you were in the price of the stock, and so you were damaged by it. Just throw out reliance. I think there's a good argument logically that makes sense. And that's kind of what my paper played around with. I didn't actually go to that extreme, the strong version. Let me say strong and not extreme. I didn't go to that strong version, but I said it was out there and it's a possibility. Instead, I really ended up where the Supreme Court did and saying, what makes sense is a rebuttable presumption of reliance. Although, again, there are all kinds of issues about how do you rebut that presumption, which is an issue which I think sort of still hangs out there.
Mm-hmm. And you went back and revisited that subject after the Supreme Court case, right?
Yeah. I wrote I couldn't let it go. I wrote another article to sort of see what courts had done in after the Basic case. And what I really came up with was they were doing all kinds of things. And again, it was a good theory. It wasn't so much a good, it was more a label. It was more a label that could be applied to various situations, and courts were becoming more comfortable with what kinds of situations those were. But is it a really coherent theory? Probably not.
Right.
But it was fun. And, my timing was really great because when I wrote that article in 1984, not much had been written about fraud on the market. And so when the Supreme Court got the case, they were looking around at the literature, who's written about this? What is there out there? And so, they found my piece. And as I said, it was quoted by both majority and dissenting. So that was that was cool.
Yeah. So at the same time you're teaching, talk a bit about the challenges and some of the gratifications of teaching. I guess you taught corporations and some other basic courses.
Yeah, I taught the basic contracts course. I taught corporations, and I taught securities regulation. Okay. Going back to somebody who really found law school interesting, I think one of the things that was hard for me to get used to was a lot of students don't find corporate law all that interesting. That was sort of like, really? But it was true. And so, I found, and I do think I got better at this over the years, I had to find ways to make it more interesting and more accessible to students, tie it in to things that were going on, newspaper headlines. It got a lot of, certainly with the tech crash in 2000, 2001, there was a lot to talk about. And also, I always thought that even if students didn't share my fascination with the subject matter, they should have a firm grounding in the principles of the law. And in corporate law and securities law, that's usually statutes. You start with statute. You've got case law too, obviously, but you've got to start with statutes. You've got to start with reading statutes and what do they mean. And particularly corporations, almost every student will take corporations because they know it's on the bar, right? They know they have to know some corporate law for the bar. And so I wanted to honor that expectation of theirs by really drilling down deep into the corporate statute, which when I taught at Pace, that was the New York statute. When I taught at Cincinnati, that was the Ohio statute. Now, I have to say, a lot of my colleagues have the notion that you shouldn't dumb down the material. You should make the students, work hard to understand the material. And that was tough love, I guess. That's good for them. I tried to do a balancing act. I didn't want to make it simplistic. But I did want to make certain, to as much as I can, that they could read the statute. They could read the statute and understand what it meant. So that's a balancing act.
At the same time, you're in a fairly pioneering group of women who are teaching corporate law.
Yeah.
There weren't a lot of you out there at that point. Who were some of your contemporaries? Did you talk? Did you meet at conferences, that sort of thing?
Yeah, there was Roberta Carmel, also an SEC commissioner. Margaret Sachs, who was teaching at the University of Georgia. She came in a few years after me. There were not a lot, as you say, there was not a lot of us, but we did run into each other at conferences, and that was helpful.
In what way?
Just to know there were other women who were going into the corporate and securities area. I know when I was at Kay Scholler in their corporate, as the junior associate in their corporate law department, there were only 3 women in that department. Curiously, all of us were named Barbara. But and so, not surprisingly, I guess, as you had, practitioners moving from practice to academia, there weren't so many women in the corporate and securities area. And I think we all, to some degree, I think me not as much as others, but to some degree, we encountered some resistance that these weren't the kinds of courses that women were competent to teach. Oh, as we were talking, I remember Cynthia Lichtenstein, who taught at Boston College Law School, was another early pioneer. And I remember we had discussions about this topic as well. So I think just reinforcing that, yes, there is a place for us here. We know what we're doing. We know what we're talking about. We shared drafts of articles. I had many, I should say also, I had many colleagues who were men who were also very generous with their time and would read drafts of articles. I don't want to suggest that that wasn't the case, but it provided some comfort to know that there were other. I remember actually, this wasn't a corporate law issue, but very early in my time at Pace, there was a conference at Cincinnati, as I recall, which was for women teaching in law schools, not just corporate women, but all women who are teaching in law schools. And there were other programs like that. That's the one that comes to my mind immediately. But just being able to talk about what it was like to be teaching at a law school, which traditionally is a very male-dominated field, although it was becoming otherwise.
Right. Well, let's do some of what you like to do, which is talk about the ideas and the concepts.
Okay.
And we get into arbitration here.
Yes.
But before we start talking about your experiences and what you did at Pace, I want to get the context so that we have a sense of what's at stake. So this is pre-dispute arbitration agreements.
Yes.
That we're looking at. Let's talk a little bit about the back history there.
Okay. So you're a customer, or let's say you're an investor. You want to buy securities. So you're going to go to a broker-dealer and open up an account. And in opening up that account, you'll sign a customer's agreement. It's a standard form contract, obviously. It's got a lot of boilerplate language in it. You're probably not going to read it. And it's going to have a clause in it, the pre-dispute arbitration agreement, which is going to require you, if you have any dispute with your broker, it's going to require you to go to arbitrate that dispute in an industry-sponsored forum, which essentially is what was for a long time called NASD and is now Finra. And that's the self-regulatory organization for broker-dealers.
Right.
So you've entered into this contract with him in advance of any dispute arising, saying that you will arbitrate this in Finra. Now, in 1987, the Supreme Court, in a case called Shearson American Express versus McMahon, held that these pre-dispute arbitration clauses were legally enforceable. This was a big deal because the Supreme Court had earlier ruled that they were not enforceable as to federal securities claims. So they reversed themselves. They overruled themselves. They overruled their prior precedent. So after McMahon, broker-dealers know these clauses are enforceable. And so essentially, FINRA became de facto the exclusive forum for deciding these cases whenever a customer of a broker-dealer had any dispute with that broker-dealer about their account. Now, at the time that McMahon was decided in 1987, many academics, including me, as well as investor advocates, thought McMahon was wrongly decided. It was really seen at that time as an anti-investor decision. Investors had deep suspicions about industry bias. Remember, this is a forum that's sponsored by the regulator of broker-dealers.
Right.
So they had deep suspicions about industry bias and also lack of transparency. They're confidential proceedings. You get an award that is public, but it has just bare bones information. It's not going to have it's not an opinion. It's not going to give you the reasons for the decision in most cases. So So that was the lay of the land in 1987. Now,
The commission did an amicus. It came in as an amicus on this decision, though, right?
yes, that was quite controversial. Because they came in support of mandatory arbitration,
Right.
contrary to their previous position. They had been persuaded that it was a fair forum and it could. I mean, that was the issue. Is it a forum that can handle these disputes and decide them in a fair way? And the Supreme Court said, yeah, it's essentially it's an alternative forum. And so it's not taking away any rights from that. That had been the argument, that arbitration took rights away from investors. It took away the right to have their dispute decided fairly. And the Supreme Court said, no, really, all they're doing is just they're moving it from the court to arbitration. And this was part of a trend we saw in the Supreme Court, a very pro-arbitration, not only in the securities area, but in other areas. Get these cases out of the courts. We've got too many cases in the courts anyhow. Let's get rid of those cases. If they can go to arbitration, they can be handled there fairly. That was fine. But you're right, the SEC reversed itself there. So now, after McMahon, to its credit, NASD, later Finra, has made many changes, and they continue to make many changes to the arbitration rules, and frequently amended their rules, both to improve their procedures, make them more regular, make them more predictable, establish a code, essentially, a procedural code, improve the procedures, and also to reduce the influence of the securities industry. So I have written many articles in which I argue that investors, in fact, have a better chance in securities arbitration than they do in the courts. Many investor advocates disagree with me on that, so that's just where it is.
So about 10 years down the road, you're contacted by the commission about this idea for a securities clinic. To tell me about the phone call, the approach, what your thoughts were.
Yeah, this was in March 1997. So you're right, it's about 10 years after McMahon. And the person who called me was Ron Long. At that time, he was an attorney in the office of the SEC chair, Arthur Levitt. And he called me up. I'd never met him before, never talked to him. But he said that Chairman Levitt was very interested in law schools setting up securities arbitration clinics. And as he explained it to me, he said the Chair Levitt had done a number of town halls throughout the country talking to investors about what their issues were. And what he heard from them was that they had difficulty arbitrating their disputes because they were having difficulty in getting legal representation, particularly small investors. And therefore, that obviously influenced their view of securities arbitration and their view of the fairness of it. So Chair Levitt thought, all right, we got law schools there. And this would be a good situation, a good opportunity for law schools to get involved and establish clinics. So as I talked to Ron Long about this, I thought, this really it appealed to me. It sounded like a really good idea. And first of all, I think, it tied in with my own interest in advocating for investors. And also it could fill a need at law schools. At that time, and this continues to this day, I think, law schools are looking to provide their students with more clinical opportunities. In other words, skills training opportunities, learning the law. As I did, I taught corporations, obviously, and I wanted them to learn the statutes, as we were talking about before. So they're sitting in a classroom, they're learning the law, but really there are important lawyering skills, and law schools should play a part in teaching their students those skills. They shouldn't just assume that once they get out there and join a law firm or go to the DA's office, whatever, they're gonna know how to negotiate. They're gonna know how to do these things. So Pace was looking around for other kinds of clinical opportunities. We had a number of very fine clinics. We had a criminal defense clinic. We had an environmental law clinic. But I thought, as this was described to me by Mr. Long, I thought, wow, this would be an opportunity for students who perhaps aren't interested in going into litigation, but they would like to have negotiating skills. They would like to have drafting skills. They'd like to learn a little bit more about securities law. And they could do it in a clinical setting. And so I thought, yeah, I signed up for it. I thought this is a good idea. And I have to say, I got tremendous support from everybody that I talked to about it. I got tremendous support from my law school. I have to give a shout out here. Vanessa Merton was at that time the director of the clinical program at Pace Law School, and she provided enormous assistance to me in establishing the clinic. Was terribly patient. I mean, I was not a clinician. I was not a skills teacher, and she was tremendously supportive of the clinic. The dean of the law school at the time, Richard Ottinger, was very supportive of the clinic. New York City, I have to say, I was fortunate in where the law school was located, because New York City has a community of experienced, highly qualified attorneys who specialize in securities arbitration. And many of them were very generous with their time and sort of bringing me up to speed on, what securities arbitration, how it played out in the real world, and I had colleagues who were NASD arbitrators, and they were generous with their time as well. So yeah.
These are a lot of pieces that you're describing, and I'm sure that you don't just bring them all together at once, but there's got to be a way that you're shaping this. Where did you begin? Is it simply trying to figure out what a clinical program looks like?
Yeah, I knew I wanted to have the skills component. We wanted students to have an opportunity to meet investors and interview them. So we also wanted to have a seminar component where they could learn. They did have to learn some law, obviously, McMahon and some of the concepts we've been talking about, Finra rules. So it starts out with, and also I wanted to have, many of the clinics were, they had a lot of credits, and how many credits you have determines how many hours it meets, and it's rough sense of how much work you're supposed to put into it. I wanted to have a clinic that was not so intense, so that students who might not otherwise think they're interested in a clinical experience to get involved in one. Also, at that time, Pace Law School had an evening program, and I wanted to design a clinic that part-time evening students could participate in, that wouldn't have the daytime time component that other clinics had. I mean, perhaps there'd be a hearing, and that obviously they'd have to do that during the day, but most people, if they're given enough notice, could arrange to take a day or two off from work to participate in a hearing. The rest of the work, interviewing clients, for example, could be done in the evenings or weekends. So first, it was sort of the structure of the clinic and how many credits, just sort of mundane things that academics worry about. How many credits, how many are going to be in the classroom, how many are going to be in skills training. And then I worked through, again, with Dean Merton, as I was talking about before. She helped me a lot working through that. I remember meeting with some SEC lawyers, and they had ideas, good ideas about what we should cover in the classroom component, what should take place in the seminar. Yes, I did meet people from Finra at this time. I met some people from Finra. I remember, I went down and I sat in on a few arbitration hearings. First of all, I wanted to get a sense, do I think students acting under attorney supervision, but would students be able to do this? Or would it be, too complex, too difficult for them? And I got a sense that, with proper supervision and assistance, students would be able to handle the work. So, I went down. I mentioned, I met with some practitioners. They were very generous in letting me look at some of their materials and discuss some of their arbitrations with me. So I felt I got up. I would not have done it if I felt I didn't think it had a reasonable shot of pulling it off.
Right. The NASD would have had a program of some sort to train its arbitration people, I would think. Was that the case?
They do. It's not. They do. I'm trying to think. Certainly, our students did not participate in that. We must have made some judgment that was not the best way of doing. Yes, actually, coming back to me now. Now that's done online. And if I were starting the clinic all over again, I might have the students just do that arbitrator training program online. At that time, it was an in-person. You went down to the NASD and you sat in a room and learned it that way. And my judgment was just better that we could do that. We could do that at pace in the seminar. And as I said, I think we had some people from Finra who came up and talked to our students about that.
So I assume you got to be an expert on arbitration pretty quickly.
Yeah, I did. I did. I got pretty familiar with it.
How did you like the experience? What was there ever a time when you said, "Oh, geez, what did I get into this for?"
I said that many times. But but I think it was a great experience for me. Selfishly, it accomplished what I wanted to accomplish, which it sort of gave my scholarship a boost, gave me a focus. It gave me something I could really hone in on and really start, after that, almost everything I wrote for a number of years involved, small investors and protecting small investors. And so that was a great experience. I enjoyed the skills training. I mean, it was nice to know. I felt I could still do it. I thought I could do a good job helping the students with that. Again, with a lot of assistance from my clinical colleagues. So, but it was challenging. And the thing about running a clinic, I learned, is that what happens many of the things can be unpredictable. In a classroom, you sort of know, you stand up there, you know what you're going to cover. These are the points you want to get across in this lecture. In the clinical work, you don't know when the students have interviewed somebody on the phone, perhaps. It sounds like they might have a claim. You bring them in for an interview, but you don't know what you're going to learn. And then let's say you interview that client and you review, the students do a deep factual investigation. They do, several interviews with the client, make certain they understand from the client's point of view what happened. They'll do a deep dive into the account statements, confirmations, whatever other documentation the clients have, I should say the investors, because they're not clients yet. They're prospective clients. They'll do, but you never know, right? You never know what they're going to say. You think that they've got a claim here. You take them on as a client. Perhaps you have the students write and file a statement of claim, which is the arbitration equivalent of a complaint. Mm-hmm. And then you have to wait and see what story is the broker dealer going to come back with. You may learn a whole new perspective from the broker dealer. So yeah, there are always a lot of things going on, and a lot of understandable anxiety among the students. For many of them, this is their first experience acting as a lawyer. And they'll need a lot of hand-holding, perhaps. So yeah,
what kind of students signed up for the clinic?
A whole variety of students, but I think in the main, the kind of students were what I had expected we'd get. We'd got students who were interested in business law. I remember we had some accountants. We had some people who had worked in the industry. And then we had other people, other people just thought it sounded like an interesting area, or they wanted the clinical experience. We got, as I said, we got part-time evening students who usually came with a different perspective. They had most of them had a full-time job outside of law school in a whole variety of fields, and they were coming to the clinic with that experience. Many of them had, pretty high-level positions in other areas. So they came perhaps with negotiating skills, because they might have been in a situation where they had previously done negotiations, for example. So we'd try to get a good mix of students.
Did you find that you got a lot of folks who were really interested in investor protection, like people who wanted to be advocates?
It's interesting. I don't think most students came in kind of with that thought. I mean, they might not have an opportunity to have thought about investors at all, but I think certainly many students were dismayed when they saw the conduct of some broker dealers in the industry. And I mean, there are good and bad apples in every profession, but in our work, we saw some broker dealers who were not acting professionally, let's say, and that bothered the students. They said, "My gosh, I didn't realize there was so much fraud out there." Because when you're focusing on this area, and you're getting letters from investors, one-sided presentations. Obviously, you're getting letters from investors saying, my broker defrauded me. You're reading these, you're talking to these investors. A lot of them became very, very disturbed by what they were reading. On the other, we also had students, and I think this is what makes teaching so much fun. We also had students who sort of looked at the investors and said, well, they were really stupid. Why did they do that? Why did they believe that broker? Nobody would believe that. That doesn't make sense. And so you also have to, go spend a lot of time talking about, empathy, put yourself in that investor's shoes. What do they know? Why are they relying on this broker? And so it would lead to good discussions.
How about those lawyering skills you talked about? What kinds of skills did this clinical experience bring forward?
Okay. And we spent a lot of time when we said, going back to thought process, setting up the clinic, we thought a lot about what kind of experience they would get in this clinic. It's arbitration, after all. It's not litigation. And so the rules of procedure, particularly when we first started in the clinic, were more informal. There's less reliance on judicial precedent. Arbitrators are free to apply equity as long as they don't disregard the law, whatever that means. And so, so it's sort of like, well, is there enough substance here to make it a valuable experience for the students? And also, many of these cases settle. So a student can be working on a case and it won't go to a hearing. So we would tell students up front, we can't guarantee that your case will go to a hearing. You may graduate from the clinic without having a hearing. That's just the way it works out. But in terms of this, but we did think that there were plenty of skills students could work on. One, interviewing, right? Again, figuring out from the client what happened here. This can be difficult because the clients may come in and all they know, frankly, is that they lost money. They had money in an account and now it's gone. Well, did the broker defraud them? Or was this market risk? You win some, you lose some in the stock market. And so this could have been market risk. The broker had to have done something wrong. That's what we tried to impress upon our potential clients. They had to either break the law or do something that was unprofessional, violated a duty that they owed to them. And so you could spend a lot of time. You do spend a lot of time, even with relatively simple cases, talking to potential clients about what had happened. So that was, an opportunity to really work on interviewing skills. How do you get the information from the client? How do you test their understanding without turning them against you, right? You don't want to nod your head. Oh, yeah. No, I understand. Absolutely. That's terrible what he did to you. But on the other hand, you don't want in the first interview start cross-examining and then, what do you mean he said this? Did he really say that? Maybe that's for the second or third interview. Then there'd be papers to go through, right? I mentioned before, account statements, confirmation statements, laying out the trail of what had happened. So interviewing, fact investigation. We did promise the students, we promised them, you always do at least one client interview, and many students did more than one. And you'll always have a significant research and writing assignment. It will either be you're drafting the statement of claim, in which you'll set out what happened, you'll set out the facts, you'll set out why this particular client, in your view, is entitled to recovery, and you'll set out a formulation of damages. So you draft a complaint. Or if you don't do that, you'll do perhaps you'll do a memo or a letter, perhaps a letter to the client explaining why you're not taking the case. We've looked at this, we understand your position is this. Unfortunately, we've concluded not to go forward with it. So those are things we could promise. We also spent a lot of time, because it was a clinic, talking about issues like time management and professional responsibility, right? Issues that come up, all the time in practice, any kind of practice.
Okay. So when this clinic started up, you got a good bit of press.
Yeah, we did.
What was the result of that?
That was, we had, I remember I did an interview with CNN. We had a couple of articles in the New York Times. There was a lovely article in the local, the chain of local newspapers in Westchester County, which is where Pace Law School is located, about the clinic. And it did, when we were starting out, one of the things we worried about was, where are we going to be able to get clients? Would any,
Right.
we're throwing a party. Will anyone come? Because of that press, we got a lot of inquiries. In our first 2 years, we got 120 inquiries. I think that was higher than it came in subsequent years because there's kind of a backlog there, and we did get all that publicity. And we were getting letters from all over the country about people who wanted our services. And obviously, we're in New York. We had to limit ourselves to cases in New York. But we got a lot of press, a lot of potential clients. And it was also, I think very good for the law school. The students who were in the first few years of the clinics, the publicity, validated their sense that this was a good opportunity. They made a good choice in signing up for the clinic. So, yeah.
The people you talked about getting support from people in NASD, the SEC, perhaps in teaching in some of the classroom work. How did you get those people to come in? Was there an overwhelming just sort of sense of duty? Could you provide them with some kind of experience or continuous education, or how did that work?
We provided them with nothing. I would call up people and ask them if they would come and speak at my seminar. And, people said yes. People, the attorneys in private practice representing investors, the attorneys representing broker dealers, they all recognized that the clinic was a good idea. They had all been in situations where they were on the other side of a case. Well, if you're a broker dealer, for instance, you're on the other side of a case where you have an investor who's representing themselves, pro se. And that's like a wild card. You don't know what they're going to say, what they're going to do. You don't know how the arbitrator is going to react to that person. It's somebody who's in an arena where they don't know the rules, the protocol. So industry people thought, yeah, this is a great idea. These people need help. And again, the private attorneys representing investors, one thing, we can talk about this if you like later, we felt we did not want to take any cases away from a private practitioner. So we had eligibility requirements. It's basically small amounts of money. And so these attorneys who represent investors thought, great, I get these letters and phone calls from investors, with a $5,000 claim. I can't take that case. So now I've got a clinic I can refer it to. So, everybody that I talked to was very encouraging. And, if you ask them to come up one evening, speak to the clinic, meet with the students, they were very generous with their time.
How about the students? What was the feedback after the first couple of years?
I think all the students thought it was a good experience. I think in a clinical setting, it depends a great deal on, what you did, what was the case, you worked on. I remember some of them were stressed out because it was a real life experience. It was different from other experiences in law school. But I think, in fact, as I recall, everyone thought it was a positive. They were glad they had taken it.
Mm. So you mentioned that when the SEC came to you with this idea, it had also come to others. Were there other law schools setting up these programs that you talked to?
I remember going to a meeting in downtown Manhattan with SEC attorneys and a number of representatives from area law schools. And I think when I walked out of the meeting, I thought, well, I'm the only one who's going to start a clinic. Because I think, law schools have different priorities and different areas they want to focus. And at some other law schools, perhaps it wasn't what they had had in mind. Fordham Law School opened a clinic very shortly after Pace did. There were a couple other law schools, Brooklyn, St. John's, in the New York area, who opened clinics. I held a conference, I think it was 97, forget, fairly early on. Yeah, I think it was 97. I held a conference to inviting other law schools nationally, inviting other law schools to come in and sort of, you can do a securities arbitration clinic and we'll teach you how. And we got a few students, I'm sorry, not students, we had a few clinicians who came. And so I think perhaps a few clinics opened up after that. It's been, clinic for a law school, clinical education is expensive because, again, when I'm teaching corporations, you can put me, one professor, in a classroom, a big, classroom filled with a lot of students. And it's a very cost-effective way of teaching. Clinic, I think we had 6 to 8 students in the clinic because you have to keep the numbers small. I mean, you're looking at everything they're doing, right? You're reviewing everything. You're sitting in on the client interviews. And so it's more expensive form of education, and law schools, have their budget issues. I tried to encourage law schools, whenever anyone reached out to me over the years, I tried to encourage them and help them anyway in setting up a clinic. Some law schools did. At one point, Finra had grants for seed money for clinics that they put out there. And at that time, there were a number of law schools who took the seed money. Unfortunately, many of those law schools, after the grants ran out, they chose not to continue the clinic. So we have not a whole lot of. I want to say 10, but that might not be the right number. But not as many as I think we need.
Yeah. Well, it sounds like at the outset that in aside from all these volunteers that you talked about, that you're kind of running this thing all by yourself.
I was running it all by myself. Yep, I was.
When were you able to bring in some help, somebody who could carry the program forward?
Yeah, going into the 3rd year. Yeah, that's when Jill Gross enters the scene. Jill Gross was a private practitioner, and I recall this quite clearly. She sent me a letter outlining her credentials and her experience and said, I've heard about what you're doing. This really sounds interesting. Is there a place for me in the program? And I remember I called her up and talked to her. And I said, I'd love to bring you on board. Unfortunately, I don't have any money. But we kept in touch and we kept talking. And eventually we worked out a way to bring her in to the clinic, first part-time and then full-time. And she came in, she actually had securities arbitration experience in private practice.
Okay.
So that was quite valuable. And then over the years, I was able to turn more and more of the responsibility over to Jill.
Right. Let's talk about the work you did. You got the opportunity to do an empirical study.
Yeah.
On arbitration in general, I guess. And you did it with Jill Gross.
Yes.
Was that the work you did for Finra?
It was done under the umbrella of SICA, which is Securities Industry Conference Association. SICA, I can't remember, but it was essentially the funding came from FINRA, and at the time, I believe New York Stock Exchange still had its own arbitration program. The money came from the regulators, although it was done, as I said, under the umbrella of SICA.
Okay, so what was the ask? What were they looking for?
All right, so McMahon, remember, we talked about that. That was decided in 1987. And as I said, since then, mandatory arbitration. So by 2007, we had 20 years experience of SRO arbitration. And yet there still was this raging debate about the fairness of the arbitration forum. Many investor advocates argued and continue to argue that securities arbitration is unfair, it's inefficient, it's expensive, and it's biased toward the securities industry. The securities industry, on the other hand, contends that the arbitration process works well, it's faster, it's less expensive than litigation, and it's fair to all the participants. So the debate at that time, in 2007, centered in particular on three aspects of securities arbitration. One, its mandatory nature. Two, the inclusion of one industry arbitrator on every three-person arbitration panel. And three, the lack of transparency in the process, because as I explained before, while there are awards, they don't usually give explanations. They set forth the claims made, the defenses made. They'll say who won. They'll give any recovery. They'll state the recovery, but there won't be any explanation of how the arbitrators arrived at that decision. And so what Jill and I thought. So Finra was thinking, SECA was thinking that it's time to do a study of the fairness of the forum. And what Jill and I thought was what was missing from all the analysis and all the studies that had been done to date was any empirical research on perceptions of fairness to the participants, especially investors. And so that was the empirical study that Jill Gross and I did. We mailed out 25,000 surveys to participants in recent securities arbitrations involving customers. And we asked them a number of questions about that experience. It was the Securities Industry Conference on Arbitration, SECA, that's what it is.
Okay. Mm-hmm.
And so you may ask, and it's a question we asked ourselves and focused a lot about, why are we focusing on perceptions of fairness? Isn't what we want to know whether or not it's substantively fair, whether or not the forum reached the right result, right? Well, as we thought about it, we realized there's really no way to determine that. First of all, the hearings are confidential. We couldn't go sit in on the hearings and make an assessment about whether it's fair. No explained awards, so we couldn't read the awards and figure out what they had done. And so we couldn't really figure out a way of really getting to the question of whether or not the forums are reaching the right result, because we don't know anything about the merits of these cases. I mean, if you wanted to determine that, you'd have to have substantially similar cases and run them through the arbitration forum and run them through litigation and see if you got the same results, right? That would show that arbitration, it's fair. It's the best they could do. Well, you can't do that because none of these cases are going to litigation, right? So we thought about that a lot, and we decided the only thing we think we can do that would contribute to this debate is just asking them, again, through a series of questions, what do you think about the process? What were your thoughts about the process? And so we asked them perceptions about the attentiveness, competence, and impartiality of the arbitrators, as well as their satisfaction with the outcome. And we had in our survey, we had a 13% response rate, which is above average actually for a one-time mailing survey. So we were pretty confident in our results. We formulated the questions with help from a research institute at Cornell University, which specializes in doing surveys. So we got expertise on drafting the survey. Okay. So you want to know about our findings?
Yes. What did you find?
All right. So the bottom line was customers had a more negative view about the most recent arbitration experience than the other participants in the process. Now, a majority of customers did have a favorable view about the arbitrator's attentiveness and competence. So that's kind of good. That's good. But a significant percentage of the customers believed that the arbitration panel was biased. And they did not believe, they were dissatisfied with the outcome. They did not believe that arbitration compares favorably with litigation. And, again, the bottom line, there are unfavorable perceptions overall about the fairness of the securities arbitration process. Yeah.
That's not Sika wanted. What that was not what Sika wanted to hear.
It was not what they wanted to hear. No, it was not what they wanted to hear, unfortunately. But I think, and the industry didn't want to hear that. The securities industry was quite vociferous in their attack on our survey, on the methodology, on the conclusions we drew from it. I mean, we stand by our results. We're confident that it was a well-designed survey, and we certainly did not skewer the results in any way. Our principal recommendations, we recommended, our primary recommendation was to eliminate the requirement of an industry arbitrator on every 3-person panel. Because again, what we heard from the customers was that they thought this was a biased proceeding, and they thought the arbitrators were biased against them. So that was our primary recommendation. Now, Finra initially was resistant to doing that. But in 2011, a Finra rule allows claimants to choose a 3-person public arbitrator panel. And that was a big change in the Finra rules. And I really think it's one of the most important changes. It was a change that I have heard from many people in the industry. They thought was a mistake, but I think in terms of addressing the problem that we saw in our empirical study, which is investors believed that the forum was biased, let's get rid of the industry. Let's give them the option of eliminating the industry arbitrator. If they want the industry's argument has always been, and it's not a frivolous argument, the industry's argument has always been, the industry arbitrator provides expertise. They know the industry. They have a better understanding about the conduct of this particular broker, whether or not it was acceptable conduct within the industry.
Gotcha. But
again, bias. So that was our first recommendation, and it was, as I said, ultimately adopted by Finra in 2011. The second one, and we were less convinced about this, but we thought, all right, what we're hearing is they're dissatisfied with the outcome, and one way of addressing that is at least give them reasons, right? Maybe that will make it more understandable to them. Because now, the investor would think it's kind of a black box. You got a hearing, you make these arguments, the arbitrators go away, and they come back and they say you win or you lose. Why? So we were less convinced about that because there are a lot of problems with an explained award. It adds on to the process. It adds sort of another complexity to the process. It opens up the possibility of judicial review, which is something that I don't think is a good idea because it just drags out the process and makes it more expensive. But we urged Finra to reconsider the issue of allowing an investor to request an explained reward. Now, currently, Finra has revisited that issue on a couple times. The current rule is that both parties mutually can request and get an explained award. And so it rarely happens because most parties do not mutually agree on that. That's kind of where that stands at the moment.
Oh, so if the investor wants an explanation, the broker has to agree.
Exactly.
Yeah. Okay.
Exactly.
Interesting. Well, let's just continue on with arbitration.
Okay.
I do want to talk about a little bit of your late career experiences, but it sounds like you were on the Finra task force on securities arbitration, and this was in the teens.
Mm-hmm. Yeah.
And it sounds like this would have been an opportunity to kind of revisit these subjects that you had looked at in the empirical study.
Yes. The FINRA formed this task force in June 2014, and they thought, well, let's just look at what we got here. Let's bring in knowledgeable outsiders and look at securities arbitration and see where the forum is and think about where the forum is going to go in the future and make recommendations. Talk about these issues, make some informed recommendations about changes that would improve the process. And in particular, they said they want to suggest strategies to enhance the transparency, impartiality, and efficiency of the forum for all participants. So this was nearly 30 years after McMahon, right? And guess what? We're still debating whether mandatory arbitration is fair. We spent quite a bit of time, the task force, we spent quite a bit of time talking about that. And what became clear is like the battle lines are formed and they're entrenched and nobody's moving. Investors, advocates believe investors should have a choice. They should be able to choose after the dispute has arisen whether they want to go to arbitration or litigation. The securities industry believes very strongly that the pre-dispute arbitration clause is appropriate and works and provides the efficiency and the fairness that the arbitration system is designed to bring about. So I put forward a compromise, which was that brokers should be required to offer at least some customers a customer agreement without a pre-dispute arbitration clause. And I have to say that went nowhere. It got no traction whatsoever. Nobody was interested in a compromise on this issue. So we ended up saying, look, we're not moving here. And, we're not moving. All we can do then, and I think it was a good thing to do, is we've got mandatory arbitration. We've got this system. So let's make it the best system that's possible. And so that's where we came out on that. What I thought was really important part of this study was that it was the first study that focused on the arbitrators. And what do the arbitrators feel and what do they need to make this a better system? And because, our survey, we were talking to the participants. We weren't talking to the arbitrators. We were talking to the customers and the broker dealers and the attorneys who represented those individuals. So it was the unanimous and strongly held opinion of the task force that the most important investment in the future of FINRA is in the arbitrators. And we had concerns that the below market compensation rate for arbitrators made it difficult to attract high quality arbitrators who would devote the time necessary to decide these cases. And we also thought that there needed to be additional and perhaps more creative ways of training arbitrators to do their jobs. I have to say, neither recommendation has gone very far with Finra.
Mm.
And you want me to tell you about our other recommendations that didn't go anywhere?
Sure.
Our second one, second principal recommendation was to give serious consideration to requiring explained awards to improve transparency. You see, we got a pattern here, right? We keep coming back to the same issues. And that's what we said here. Look, opaqueness, if we want to have a system that's more transparent, well, you got to explain. The arbitrators should be explaining what they're doing. Again, we recognize that this would require more training of the arbitrators. We want to make certain that the arbitrators, again, we don't want them writing legal opinions, but we want them to concisely and clearly state the reasons. That would be the objective, clearly and concisely state the reasons for their decision. Mm-hmm. And we thought, that's not an easy task to do. As anyone who's done, tried to write something succinctly, you learn very quickly. It's awfully hard to do that. So we thought there should be additional training. This is another area where the Finra has not moved on this. Again, they've considered our awards at several times, or requiring explained awards, but the rule is, as I stated previously, that both parties have to request it.
Right.
We did have, and one other thing I want to mention, because we started off here with Securities Arbitration Clinics, and that was, we spent a lot of time talking about that. Another one of our recommendations was that Finra use some of the money it collects in fines and penalties to provide funding for securities arbitration clinics at law schools. And, again, seed money for law school clinics. And Finra did not accept that recommendation either. We did I'm making it sound like we didn't accomplish anything in this task force report, when actually we did. We had 51 recommendations, and Finra accepted most of those, many of those, if not most of those, in some form or another. So I do feel like we made a contribution. I do feel we made incremental steps in improving the forum, but not radical change.
Yeah. So in retrospect, you're looking at this entity here, that the Securities Arbitration, that you unknowingly devoted a good chunk of your lifetime to.
Yeah.
Has there been progress? You talk about sort of a stalemate of sorts, but looking back to when you were first able to start the clinics, do you have reasons to think that this, while maybe you're stuck with this entity, is it a good one to be stuck with?
I think it is. I really do. I mean, again, I really do think if I'm representing an investor, or if I am an investor with a dispute with a broker dealer, I'd much rather be in arbitration than in court. I don't want to go to court. Oh my God. The broker dealers can throw up so many defenses and so many arguments, and they can take you to depositions. And then if you got a favorable decision, they could appeal it, Also, as someone who studied securities law for a long, long time, the law is not particularly investor friendly. Mm-hmm. They say, you assume that risk, or you should have asked more questions, or, so I think the Securities Arbitration Forum, where arbitrators are allowed to apply equity, get to a right result, get to a fair result, I think it's a much better system. And what I've seen, as I mentioned earlier, I think over the years, Finra has devoted tremendous resources, both financial and staff time, to improving the forum. And they've done many, many, many rule changes over the years. I mean, they're constantly rethinking this process.
Okay.
As witnessed by having the task force, and so the forum has changed a lot since I've been involved with it back in 1997, and I think it's definitely been for the better.
Okay. I want to cover a few of the other things that you did before we wrap up. You were involved in something called the Investor Rights Project at PACE.
Yes, that was Jill Gross's baby. And I was delighted to work with her on that. The PACE got a grant, a $200,000 grant, arranged through the New York Attorney General's office, and to advocate on behalf of small investors. And we ran some educational programs for small investors. We fostered research on topics related to investor justice. One of the things I'm most proud of that we did, because this goes back to students' skills training, we supervised students in the drafting of comment letters to either Finra or the SEC on proposed rule changes. I've been talking about all these rule changes that Finra did. To change one of their rules, they have to put it out for public comment, and then if they approve a rule, it has to go to the SEC. The SEC has to approve any Finra rule as being consistent with the Securities Exchange Act. So, and they will put the rule out for public comment. So there'll be at least one, if not two, opportunities to comment on a rule. And so from our perspective as advocating for small investors, we would file comments on these proposed rule changes, and it was a tremendous research and drafting experience for the students. I think the ones who worked on it would tell you that it was a real challenge for them, and improved their research and writing skills tremendously.
Okay. What was it about PACE that made it the place where these things happened?
I think probably we were a young law school. We didn't have a lot of tradition. And so, I can imagine if I had presented the idea of a clinic at some other law school, the dean would say, no, we can't afford that. Or the faculty would say, you teach corporations. Why do you can't run a clinic. At PACE was like, all right, you want to do this? Let's give it a shot, and I think that you get with a new law school.
Okay. Well, you moved on. You went to Cincinnati. Why the move there?
Well, it was 2006. I joined the faculty at PACE in 1978, and I thought, well, maybe it's time to move. And I had been spending all that time, and I loved it. I loved every minute of it, almost every minute. Probably there's some that I didn't, but I spent all that time working on the clinic, advocating for small investors. And I thought, maybe I should try something else, maybe. And so I moved to Cincinnati. I became the director of their corporate law center, and ran a number of, and it did get me to think about other areas of corporate and securities law. So we ran a program on corporate governance. We ran a program on federal securities class actions. It was an opportunity to sort of look at other areas. I worked on developing a stronger business law curriculum for them. Interestingly enough, I decided Cincinnati was probably not the right place to have a securities arbitration clinic. So we opened a small business clinic where we hired a clinician. It wasn't me this time. We hired a clinician to run a student to work, we hired a clinician to work with students, to work with small business owners and develop their businesses. And I thought that was a really great improvement. Addition to the curriculum. So it was sort of expanding my opportunities and trying different things, meeting different people.
So the Corporate Law Center was an umbrella to enable you to pursue all these things.
Exactly. Yeah, basically, that was the attraction of the job, because I was interviewing for the position as professor and director of the corporate law program. And the corporate law program had been in existence for quite a period of time, but it had not been active. And so I said, well, what do you want to do with it? And they said, whatever you want. I thought, oh, okay, I can run with this. So yeah, it was fun. It was fun.
So once again, there's an opportunity to look into all kinds of things.
Yeah, exactly.
Well, this has been really interesting.
Thank you.
And it's great to we focused on arbitration a lot, but we've touched on a lot of other things as well. Yeah. Is there anything that we've missed that we should discuss before we wrap up?
I think the one thing I would say, this goes back to what I was talking about with the task force with arbitrators. And I think, I serve as an arbitrator, and I'm retired now, but the one thing I continue to do is to serve as an arbitrator on Finra arbitration forum. And so I think that has informed my experience about the securities arbitration process in a different way than as an investor advocate or as running the clinic. And I mean, I currently have, I checked this yesterday, so I'd have the number. I have 6 active cases. And I consider myself an active arbitrator. You're assigned a case, and you can either accept it or reject it. And then, so it's piecemeal, right? It's occasional piecemeal work. And yet, as I've talked about, Finra has adopted all these rule changes which have improved the procedures. They've also put additional responsibilities on arbitrators. And this was, really what the task force was concerned about. Are there the right incentives to make certain that the arbitrators are doing the work competently and conscientiously? I wrote an article. It's an article that didn't get much play because it was published deliberately in a practitioner's journal, but I wrote an article in 2004. The title of the article really says it all. It's, "Do we expect too much from NASD arbitrators?" And my answer to that was, yes, we do. So I think that's something, just to kind of add to the mix. If somebody is listening to this and thinking about securities arbitration, wants to know more about that, I think it's important to focus on the work of the arbitrators and the challenges that presents.
And that'll have to be a task for somebody else, I guess.
Absolutely.
Well, thank you so much for talking to me today. I really appreciate it.
Thank you. I enjoyed it. Thank you very much.
All right. Take care.
Take care. Bye-bye.